Hello and welcome to PTAB Motion to Amend, a niche within a niche, hosted by Virtual Patent Gateway and sponsored by Unified Patents and the Unified Network. Virtual Patent Gateway founder Ashley Chung has a passion for supporting the next generation in the workplace and is committed to developing a growth mindset within VPG. Our moderator, Kelly Hughes, is Senior Patent Counsel at Unified Patents LLC, where she supports Unified's PTAB practice along with appellate practice. She was previously a patent attorney at eRise IP, focusing on patent litigations and PTAB practice. This webinar will be recorded for future use, and we have applied for 1.5-hour Virginia and Maine CLE. Ashley will notify you when it is approved. There will be a short Q&A at the end of the presentation. And with that, I'll hand it over to Kelly.
Thanks, and hi everyone. Welcome to our panel discussion. I am the moderator today, and just to start off, I just wanted to kind of give the disclaimer that any opinions of the panelists today are their own and they don't reflect the opinions of their employers, and also that this is continuing legal education, but not legal advice itself. That being said, for all of our participants today, feel free to ask questions in the chat. We may take them as we come or hold on to some for the end. We'll have some time at the end for questions as well. And I'm now going to turn it over to each of our panelists to introduce themselves. First, we have Alyssa Holtzlander. Go ahead, Alyssa.
Thank you, Kelly. Hi, everyone. As she said, my name is Alyssa Holtzlander. I work for Unified Patents. I'm the Senior Patent Counsel, and I also lead up our Unified Brands program that we have for counterfeiting. I've been doing IP work for a while. I worked at Finnegan prior to coming to Unified for 10 years, and now I've been at Unified for 4. I've had experience on both patent owner and petitioner side of IPRs, but now for Unified, I'm always on the petitioner side.
Thanks, Alyssa. Next up, we have Jessica Kaiser.
Hi, everyone. I'm Jessica Kaiser. I am a partner at Arnold & Porter K. Scholler, LLP. I'm based out of the Denver office. I've been in private practice for a number of years, but most recently just back for a year after having spent a little over 7 years as an administrative patent judge at the PTAB. And while I was at the PTAB, being heavily involved in motions to amend, including the motion to amend pilot program that we're going to talk about. So happy to be here. I focus my practice primarily on both PTAB proceedings, primarily IPRs, as well as a district court litigation involving patents.
Thanks, Jessica. And for our last panelist today, we have Kevin McNish.
Hi, everyone. I'm Kevin McNish. I run McNish PLLC. It's a cloud-based patent trial and appeal board and federal circuit practice in beautiful Portland, Maine. My practice has historically split and still does split between about 1/3 petitioner side work and about 2/3 patent owner side work. And in addition to representing clients at the Patent Trial and Appeal Board, I also do a fair bit of work at the Court of Appeals for the Federal Circuit, principally appeals of Patent Trial and Appeal Board proceedings.
Thanks, Kevin. Now we can turn to the first section of our panel today, where we're going to talk about law and procedure, and Jessica is going to talk about that.
Yeah, so if we could go to the next slide, I'm going to start by just walking through some basics about motions to amend and where some of the requirements for motions to amend come from, just so we have a basis for our discussion today. And so the first sort of source of authority is this Lectrosonics case, which is a PTAB precedential decision from 2018. It talks about the requirements for motions to amend. And specifically here you see that the patent owner, when filing a motion to amend, has to show support for all claim elements in the original patent application and any priority documents. One One thing here is I have seen over time a lot of people cite their support in the issued patent rather than the original application. And so I just note that it's important to make those citations to the original application. The patent owner has to include a claim listing that shows all the proposed substitute claims. And although the board doesn't have a specific requirement for how you show the changes, you have to show sort of what changes you are proposing to make to the original claims. And the patent owner, I'll talk a little bit about burdens in a bit, but the patent owner has the burden as to specific statutory and regulatory requirements for the motion to amend, but ultimately the petitioner then has the burden to show that any proposed substitute claims are unpatentable by a preponderance of the evidence. If you go to the next slide, these are the statutory and regulatory requirements on which the patent owner has the burden. So reasonable number of substitute claims, there is a presumption that a one-for-one proposed substitute, in other words, proposing one substitute claim for each original claim, is reasonable, but that can be rebutted. Your amendment in front of the PTAB has to be responsive to a ground of unpatentability. Basically, it just can't be untethered to the proceeding altogether. It has to have something to do with what the petitioner raised in the petition. But you can also address other potential issues with your claim that might not be responsive to a ground of unpatentability, like 112 and 101 concerns. The patent owner can't enlarge the scope of the claims of the patent, and the patent owner can't add new matter, and that goes back to the requirement to identify support for the limitations of your proposed substitute claims.
And just to quickly jump in here, so for all of the panelists, I guess I was just wondering, has anyone had any personal experiences where the board allowed for more than one substitute claim?
So I'll say for my part, I have definitely seen where if the patent owner gave some sort of rationale for why they needed more than one, then I've seen the board allow that. I think where patent owners sometimes get themselves into trouble is they don't either give that rationale, or they don't sort of clearly explain how the proposed substitute claims correspond to which original claim, and then it looks like maybe they're proposing more than one for a specific original claim. So I think if you want to do that, it's really important to sort of explain why in a clear way.
Okay, thanks. I think I can let you move on now.
Okay, if we go to the next slide. So I mentioned this just a minute ago, but there is also a board precedential decision, the Amazon.com decision from 2019 that talks about that you're not limited for opposing motions to amend to 102 and 103 grounds. That is, you're not limited to just for example, in IPR, the 102 and 103 grounds based on patents and printed publications. And so in opposition, a petitioner can raise, for example, 112 grounds like written description and enablement, and can also raise 101 grounds. Next slide. And then there is the Hunting Titan case. And this is sort of an interesting quirk of the motion to amend practice, because for anyone familiar with IPR proceedings, the petitioner, has the burden to prove unpatentability of the original claims by a preponderance of the evidence, and the board can't really fix that for the petitioner. But in motions to amend, it's a little bit different, and the board can, at least in some circumstances, justify denial of a motion to amend on its own. And that, no, I think we just lost the slides. So, you know, the specific examples that the board has provided for when it might itself justify a decision on a motion to amend, even if the record didn't support it, is if the petitioner has ceased to participate. And that could happen, for example, if you know, the petitioner felt like the claims were amended in a way that they didn't have concern, and so they didn't want to spend their resources opposing the motion to amend, for example. And then the board has also said it will generally only do this if the ground is readily identifiable and so persuasive the board should take it up in the interest of supporting the integrity of the patent system. And so generally what that means is the board's not going to dig through sort of the record and try and cobble together its own ground. But if there's something that, you know, is sort of smacks you in the face, the board doesn't have to ignore that, even if it's not particularly raised by the petitioner. If you go to the next slide. And just to note that in December of 2020, the board did put forward rulemaking where to clarify the burdens for motions to amend. And so the statutory and regulatory requirements I mentioned earlier, those are the patent owner's burden to show. And then on unpatentability itself, the petitioner has the burden to prove unpatentability. Next slide. And then this is the rulemaking that goes along with the Hunting Titan case that I talked about before. So the board did follow that decision up with rulemaking to note that it can itself grant or deny motion to amend based on the interest of justice. I mentioned before about denying a motion to amend, but the board can also use this rule to fill in a potential gap that the patent owner may have, and that's the granting the motion to amend piece. And so, for example, if the patent owner failed to specifically argue to show that it had met one of the statutory or regulatory requirements, but there was readily identifiable and persuasive evidence in the record for that, then the board could potentially fill that gap for patent owner as well.
And yeah, I guess just maybe other panelists feel free to jump in. I was just wondering, has anyone here experienced a situation where the board raised a new ground that the petitioner didn't advance, or is this especially rare?
So I can jump in on that. I've seen occasionally where there's an antecedent basis issue raised by the amendment that the patent owner did not fix. And at that point, the board has sometimes said, hey, you've got an antecedent basis here. This claim's indefinite as you've got it written. You need to fix this in whatever revised motion to amend you're going to file.
Okay.
So interestingly, I've seen it where there was a specific ground of unpatentability raised as to the original claims, and the board found that whatever the proposed amendments were, that they didn't actually meaningfully change the scope of the proposed substitute claims, but for whatever reason, the petitioner didn't bring that same ground from the petition over to the opposition to the motion to amend. And so I've seen, not common, but occasionally the board reach back to the original petition to pull that ground over.
Okay, that's interesting. So maybe a little more common than I thought.
All right. Yeah, and I don't, just to clarify, I don't think it's super common, but I do think you see some instances where the board may have seen something, it's clearly in the record, and they don't have to sort of put their blinders on like an ostrich and pretend like it's not there. So if we go to the next slide. So this is also part of the final rule where, you know, the PTAB can only rely, and this again is in filling any gaps for the parties, evidence that the rule says either from a related proceeding before the USPTO, so it could be, for example, the same panel knows about something from an ex parte re-exam or from some other related proceeding, or that a district court can judicially notice. And that has always sort of been an interesting one to me. I don't think I've seen cases before the board that specifically test that. I'm sort of curious if anyone else has seen that. Sounds
I
like
have not seen that.
I haven't seen it
at all either.
Yeah, so I don't think this has become a contentious issue, but I did think it was interesting language to include in this particular rule. And then the final point about this rule is it clarifies that the parties will have essentially notice and an opportunity to respond if the PTAB is going to step in to fill a gap. And so what that means is basically, you know, say, you know, the PTAB was going to pull in another ground of unpatentability. Before they would actually issue a final decision on that, they would give the patent owner notice and an opportunity to be heard about, you know, whether that's appropriate and the patent owner's view as to that ground. So if we go to the next slide. And again, we talked about some of these precedential decisions before, but this final rule was intended to be consistent with the practice that was already set forth in the board's precedential decisions. Go to the next slide. And then just wanted to flag that there was a Federal Circuit precedential decision in Hunting Titan, where the Federal Circuit looked at essentially, does the board have an affirmative duty to raise these sorts of patentability challenges sua sponte? And the board, or the Federal Circuit, found that the board does not. You know, the Federal Circuit Hunting Titan leaves a lot of issues open because you know, they said they weren't determining the patentability of the proposed substitute claims. Okay. And they didn't determine whether the panel abused its discretion in determining whether the particular ground at issue was readily identifiable and persuasive. But part of that was based, my understanding, on a waiver issue where the party hadn't really presented that issue to the Federal Circuit. So I guess, you know, the takeaway from Hunting Titan, the Federal Circuit version, is you know, the board is not necessarily required to sua sponte, comb through the record and find patentability challenges, but more to come on interpretation of whether grounds are readily identifiable and persuasive.
And so I guess one question I had was, do you or any of the other panelists think that the outcome in Hunting Titan here could encourage the board to be more aggressive in exercising its discretion to raise these grounds sua sponte?
I don't know that it'll necessarily make the board more aggressive, because I think if you know, when you start looking at the facts of Hunting Titan, it's a little surprising the petitioner here, you know, didn't I think bring up the grounded issue. And you know, as in, you know, my experience as a petitioner opposing motions to amend, you know, I want control of the grounds that I want to apply to the claims, and I'm gonna, you know, fit as much as I can into my 25-page opposition.
Thanks, Kevin. That makes sense.
Yeah, and I'll just say, you know, I don't necessarily read the the decision as encouraging the board to be more aggressive. I do think, you know, there's sort of a tone of it of, you know, if it's in the record, then sort of why wouldn't the board? But, you know, I don't think it's going to encourage, for example, judges to go out on a limb if it's not really, you know, like I said, smack you in the face in the record.
Okay, well, thanks.
Let's go to the next slide then. So now I'm going to switch gears and talk about the motion to amend pilot program. And it is sort of interesting because the motion to amend pilot program came out in March of 2019. And now it's April of 2023, and it's still a pilot program. It's been extended a number of times. But basically, the motion to amend pilot program was designed to respond to concerns expressed by those in the community that in IPRs, there wasn't really a meaningful opportunity to try to amend your claims. And so the motion to amend pilot program really allowed for two procedural options for patent owners. One is to request what's called preliminary guidance from the board. And it's in some ways kind of akin to a DI in that it gives the parties a sense of where the board thinks the motion to amend sits after, just based on the motion and the opposition. The board typically gives that preliminary guidance about 4 weeks after the opposition. And then after getting that preliminary guidance, the patent owner can choose to file a revised motion to amend. And so that gives the patent owner the opportunity to take into account the opposition from the petitioner and the preliminary guidance if the patent owner requested it, and to really be able to respond to that. On the other hand, the patent owner doesn't have to file a revised motion to amend, so the patent owner can sort of stick with its original amendments and file a reply based on its original motion to amend and go from there.
So do any of the panelists think there were any big effects coming from the pilot program that, you know, maybe we'll get more into this when we talk about practice tips, but were there any big changes anyone noticed from this?
I mean, I think the fact that the patent owner gets preliminary guidance now is a huge change, and I think we'll get into more of that too with the tips. But there are so many details that patent owners have to be aware of when filing their motion to amend to make sure, you know, they're not broadening the claims, they're not, you know, doing any of the things that Jessica was talking about earlier. So I think getting that preliminary guidance is huge because you kind of get a second bite at the apple to fix errors you may have had in your first motion.
Yeah, and it seemed like to me that this also creates a lot of a lot of deadlines that can be pretty tight.
Yeah, I'd say there's no question that the pilot program created a very aggressive schedule, both for the parties and for the judges. You know, I think from a sort of procedural and standpoint and perception of fairness, it does create a situation where there's less opportunity for surprises. So, you know, one of the criticisms before the pilot program had been, well, I get all the way to the end and then the board says I made this one little mistake, so they're going to deny the motion to amend. And, you know, with these pilot program options, really the patent owner has an opportunity to get that preliminary guidance to hopefully, or to, you know, to potentially flag some of those issues so that you know, when they get to the final written decision, they're really looking at the meat of it.
Thanks.
And Kelly, you mentioned the tight schedules and stuff.
Yeah.
I also wanted to say, my biggest takeaway from that piece has been, if you see one of these in one of your cases sort of looming on the horizon, you really have to plan ahead. Sometimes in IPRs, I feel like people kind of wait until the last minute to figure out deposition scheduling and things like that. And you just don't really have a ton of time, particularly in the schedule with the revised motion to amend. And so I think in order not to have everything be your hair on fire running around, you really have to communicate and plan ahead about when things are going to be scheduled. All right, let's go to the next slide. And I think these last slides really just show the timeline that we were talking about. This is in the Federal Register notice for the pilot program. This particular timeline shows at the top the default schedule for the briefing on the petition. And then the bottom timeline shows the timeline for briefing on a motion to amend if one is filed. And you see there the preliminary guidance on the bottom timeline coming about 4 weeks after the opposition to the motion to amend. If we go to the next slide. And then this is where it gets really fun with the compressed timeline. This is the timeline if the patent owner chooses to file a revised motion to amend. You can see that down on the bottom timeline, the first sort of black circle. And that really gets compressed because then the board does allow sort of the full briefing cycle on that revised motion to amend.
And so I think we're about to turn to our next section, but I guess one last question. So I think the pilot program was implemented in March of 2019. And I guess given that it's been a pilot program for a while now, just wondering whether any of the panelists think that it, should become permanent, or if it has been a good addition.
Yeah, I'll say from my standpoint, I think the office should make it permanent. It's part of the practice now and has been for almost 4 years. And frankly, I don't hear a ton of people saying negative things about it other than the timeline. And if you want to sort of have these opportunities to file the revised motion to amend, to get the preliminary guidance and do it all within the statutory deadline, it's a little hard to figure out how to make the timeline more forgiving.
Yeah, I'd also support making it permanent. I think further to a point you made earlier, Jessica, it avoids that sort of surprise issue at the end of the proceeding where, the patent owners file the motion to amend and then things go into the void for a little bit. And the patent owner doesn't get any feedback until the final written decision. So here, there is that moment of feedback, whether that makes making a motion to amend worthwhile, given some of the other options for amending claims available. I'm still not totally sold on using this program as a patent owner, but it's better than it was before. And for those reasons, I'd support making it permanent.
All right, thanks, guys. I think we can turn to the next section. It's trends and statistics, and I think Alyssa is going to talk about that today.
Yes, thank you, Kelly. We can go ahead and go to the next slide. So the statistics we're going to be looking at are from the USPTO website and include data through March of last year. So you can go yourself and see these charts on the patent website and also some additional charts that they have. On this slide, it shows the overall statistics for the number of cases in which motions to amend have been filed. And you can see in a large majority of the cases, there are no motions to amend. Only about 10% of the cases have had motions to amend filed in them. So we're still not seeing a ton of cases that include this motion to amend program. There are, like I said, a few, but patent owners aren't really jumping on this in all of the cases. And there can be a lot of reasons for that, that it's difficult to win motions to amend. And then also, if they're in litigation, they don't want to have the chance of getting rid of the claims that they've already asserted against defendants. Next slide. All right, this slide shows the trend of how many motions to amend are filed each year. As you can see, there was a spike in the number of motions to amend filed in 2018 prior to the start of the pilot program. And since then, we've seen the number kind of gradually decrease each year. And, you know, in the last couple of years, there just haven't been quite as many. I think, you know, like I said, motions to amend have been historically difficult to win, as we're going to see on some of the other slides. And patent owners are starting to turn to other methods to amend their claims, such as through re-exam, to try and have better odds at getting the amended claims. And Kevin's going to talk a little bit more about that later. Next slide, please. So this slide shows the percentage of motions to amend that are granted. As I just mentioned, it's not a high percentage. Overall, about 16% were granted either in full or in part. Following the introduction of the pilot program, we have seen an increase in that number to about 25% being granted either in full or in part. And when looking at how the pilot program is structured, you would expect there to be an increase in grants because the patent owner is now getting that preliminary guidance and an opportunity to fix certain issues in their motion to amend based on feedback from the board and seeing the petitioner's original opposition. Go to the next slide, please. Again, this slide is just showing the increase in the percentage of motions to amend that have been granted before and after the pilot program started. You can see that the percentage of grants has increased by 11% between the pre-pilot motion to amend and the pilot program motion to amend.
Yeah, I guess to jump in really quick, I know that in motions to amend, petitioners are able to bring in, you know, new art to overcome the amendments. And just like in anyone's general experience, have you seen any success in the outcomes of motions to amend affected based on whether new grounds have been presented by the petitioner or if they're relying on the same grounds?
So I think it really depends on the type of amendments that the patent owner is making. Sometimes the patent owner may just be making an amendment to clarify a claim construction position that they're taking and asserting, you know, that the original art doesn't have that. And the petitioner really has to decide if, you know, they think that that issue is addressed by the original art or if they need to do another search. I don't have the statistics on the difference between, you know, whether or not the original art is used versus new art. But the statistics do show that often motions to amend are denied because the patent owner didn't meet their burden. So the art wasn't even looked at. For example, this occurs often when the board finds that the amended claims contain new matter, or don't have appropriate written description, or that the amendments enlarge the scope of the claims. Those are kind of the three top reasons the board finds the patent owner not meeting their burden.
Okay, thanks, Alyssa. And I think that wraps up our section on the statistics and trends. So I think we'll have Kevin now talk about processes and procedures after the motion to amend.
Thanks, Kelly. Why don't we start with the appellate review section? So if you have filed a motion to amend and the case is going to a final written decision, more likely than not, your next stop is the federal circuit. That's just a fact of life. Most of these IPRs involve some kind of co-pending district court litigation. So as I like to say, the final written decision is often only the beginning. So what's on this slide here is a list of issues and the relevant standards of review at the federal circuit for those issues. Patentability issues for amended claims at the federal circuit are essentially the same as they would be for original claims. So, you've still got substantial evidence review for factual issues. That's generally a very deferential standard of review. You also have de novo review for legal issues, including claim construction. That's where the federal circuit can take a look at the legal conclusions the board has drawn de novo. And one sort of last point on, whether the board should have reached a ground sua sponte. This comes out of the Hunting Titan Federal Circuit case that Jessica discussed earlier. That's considered, that's reviewed as whether the board applied its own procedural regulations properly. That's reviewed for abuse of discretion, also a fairly deferential standard. So, one of the things you can see from this chart is that while there are many issues reviewed de novo because they're principally legal issues, a lot of the bread and butter issues that you're going to face in IPR, namely anticipation and obviousness, are principally reviewed for substantial evidence. And a big one also that comes up a lot in motion to amend practice is written description and new matter. The new matter, the patent owner has the burden to show that the proposed amended claims don't contain new matter. And for that, they essentially have the burden of showing that the original specification, original application, and the originals of any parent applications in the priority chain provide adequate written description. That's reviewed as a factual issue. The key takeaway here is that if you do not prevail on a written description or new matter issue as a patent owner at the Patent Trial and Appeal Board, you have an uphill battle awaiting you at the federal circuit because substantial evidence, again, very deferential standard. The court essentially says, could a reasonable mind have come out the same way the board did, presented with the evidence that the board considered? And as you can imagine, fairly deferential standard. You also have motions to amend subject to review under the Administrative Procedure Act. This simply ensures that all parties involved had adequate notice and were appropriate to submit rebuttal evidence or evidence in support of their positions generally. This comes up a little bit less often now that preliminary guidance is available and there's much more notice of issues than there used to be, but this is also part of the notion that when the board does something sua sponte, it has to give parties notice and an opportunity to respond. So we can go to the next slide, please. So one of the lesser seen aspects of, or lesser thought about aspects of motion to amend practice is the trial certificate. The trial certificate is not the final written decision. It's not the federal circuit decision. It's not even the mandate from the federal circuit decision after the appeal. It is a document that the patent office issues at the conclusion of all appeals or until the time for taking further appeals has expired. And even then, it usually still takes a couple weeks or even months for the office to issue a trial certificate. Now, that's important because the amended claims don't actually exist until added to the patent via the trial certificate. As a consequence, the patentee cannot assert amended claims, even if the patentee has gotten those claims through the Patent Trial and Appeal Board and through the federal circuit, until the trial certificate has actually issued. And that comes out of a district court case. This is this Pulse Electronics case from 2021. Again, this is something to keep, we'll talk about this more later, but this is one of the things that actually makes motion to amend practice a little bit slower in some instances than pursuing claims via continuation applications, if available, or via reexamination or reissue. Next slide, please. So in addition to slowing things down a little bit, in addition to not being able to assert claims until they're actually in the patent via issuance of the trial certificate, the patent owner also has to keep intervening rights in mind. Intervening rights is a doctrine that basically says the patentee, that essentially takes away damages from the patentee based on an amendment after issuance of the patent. There are two principal flavors of this. One is called absolute intervening rights, and under the doctrine of absolute intervening rights, when there is a claim amendment, the patentee cannot claim damages prior to the amendment against an accused infringer. The other is called equitable intervening rights. Equitable intervening rights essentially cuts off the patentee's future damages in an equitable fashion. So for instance, where the accused infringer has made substantial preparation in preparing or manufacturing articles that might meet the claim limitations, but sorry, I'm losing the thread a little bit here. Essentially, where the accused infringer has made substantial preparation to manufacture an article that might be covered by an amended claim, equitable intervening rights can cut off some past damages just based on equity. And so it's a very factually intensive process. It's a very case-by-case process. Sort of the two takeaways you need to know as a patent owner considering a motion to amend is you're always going to face absolute intervening rights. You're going to lose past damages, and you're going to an extent, lose future damages as well. The bar is not quite as absolute as absolute intervening rights, hence the name, but you need to understand your damages window shrinks, and it shrinks by quite a bit via motion to amend practice.
And so just to jump in quickly, have you seen, or has anyone else seen any actions that the patent owner has taken to kind of protect themselves from these intervening rights during motion to amend practice?
So I haven't, and I think kind of the issue you would run into there is if you are amending your claims in such a way that you've maintained, purportedly continuity of scope, continuity of claim language, you're not really distinguishing the claims over the prior art that's been asserted against you. And meanwhile, you've also opened yourself up to a whole bunch of 101 and 112 issues on the proposed amended claims. So I haven't seen it done. It seems to me like it would be a pretty significant strategic mistake. But certainly anything's possible. I'd be interested, Alyssa or Jessica, if you've seen, or Kelly, you as well, if you've seen someone try to do that.
I'll say I haven't seen anyone explicitly try and do it. I have seen cases where the amendments are not particularly meaningful, the proposed substitute claims, and I wonder if that is part of it, is they're trying to walk that line. But as you said, Kevin, I think it tends not to be successful for motions to amend. If you're not really changing the scope of the claims, then you're really not getting away from the unpatentability grounds that existed for your original claims. So I wouldn't be surprised that was what people might have been trying to do in certain circumstances, but I don't think it generally is a successful strategy.
Mm-hmm. All right, why don't we go into the next slide, please? So we've talked a bit about, what happens at the Federal Circuit after a motion to amend. We've talked about, what it takes to actually get an amended claim into a patent. So now let's talk about, what happens once those amended claims are into the patent. If you take a look at the estoppel statute, you will see that estoppel applies to a claim in a patent. Well, one open question that actually, believe it or not, still remains open today is whether a new or amended claim is considered in a patent. for purposes of applying IPR estoppel to that claim. There's no real dispute that IPR estoppel applies to claims that were actually challenged during an inter partes review, but substitute claims aren't actually in the patent until the trial certificate issues, and that's not in the inter partes review, that's after it. So, we were hoping, I was really hoping back in 2021, when we did an earlier version of this, that we were going to get an answer of that out of that Pulse Electronics case we talked about a few slides ago. Unfortunately, that case settled. So, and you can imagine why this is still something of an open question. Just imagine the confluence of events that would have to happen for us to get an answer on that. Motion to amend has to be granted. The claims that come out of it have to still be worth asserting after intervening rights. The case doesn't settle, and a case actually gets to the point where IPR estoppel actually gets raised as a reason not to hold the claims invalid in district court litigation. And you can sort of see, like, with all of those hurdles or all of those sort of prior events that would have to take place before us to get a decision on it, how this is actually still an open question after all these years. And so, because that's still an open question, we also don't know what the scope of reasonably could have been raised estoppel looks like for those claims as well. Is it skilled? Is it, the typical skilled searcher exercising reasonable diligence that we see for an IPR petition? Do the compressed timeframes involved in a motion to amend actually affect what a skilled searcher could have done and the reasonable diligence that a skilled searcher could have exercised with respect to proposed substitute claims? Or, if that estoppel doesn't apply to amended claims, then, it's a question, we don't really need to ask. So it's, there's still some uncharted territory here. And, it'll be interesting to see, if this territory does get charted in the next couple of years, what that might look like, whether that will make it to the federal circuit, and when we're going to get some controlling authority on this issue.
Thanks, Kevin. And just, I guess, we talked about these open questions and just wanted to open those up to our other panelists to see if they had any thoughts on those before we turn to our next section.
I would just go on with what Kevin was saying with the compressed timelines. I mean, for the petitioner in these cases, you have a certain amount of time after the original motion to amend. But if the patent owner substantially changes their claims in the revised motion to amend, I mean, there's only 6 weeks that you have for doing a search, preparing your response. And that does make it much tougher than, when someone is originally preparing an IPR to be able to do their diligence to find art.
Okay, thanks, Alyssa. So I guess we'll turn to our last section where we're kind of all going to talk about practice tips. And just to start with, we're going to start with practice tips for patent owners, which would be the next slide. And so I guess opening it up to the panel, what do you think the best tips are for patent owners for motion to amend practice?
Yeah, so I can jump on that. My number one tip for patent owners tends to be don't. I think those of you who saw my LinkedIn post yesterday got kind of a flavor of this, but you have a lot of better options and a lot of faster options and a lot of options that don't involve some pesky petitioners counsel raising 101 and 112 and all kinds of other grounds against you. That can include reissue, that can include re-exam, that can include, if you've got a continuation, filing it with a track 1 request. And often, especially with a track 1 request where, you're likely to get a final disposition within about a year of filing, well, that's going to be faster than litigating a motion to amend and then going to the federal circuit. With so many other options available to you that are often faster, that often involve that often have more limited participation, if any participation available to a patent challenger, very often you've got better options. You've also got to think about just sort of the overall business case, right? Like, am I okay with what, my damages case looks like after intervening rights kick in? On the other hand, how much patent term is left in my patent? On the other hand, like, do I need to keep at least one claim of this patent alive, regardless of what it says, because I've got some kind of royalty-bearing agreement as a licensor that says, well, as long as one claim is active, doesn't matter what the claim actually is, I get royalties off this. I can tell you, I've done 60-something IPRs, patent owner side. I have never once filed a motion to amend. I've never once seriously considered filing a motion to amend, just based on a lot of all of this stuff. So think about your other options. But if you're going to do it, think carefully about the business case. Proofread your claims very, very carefully, because the board is not going to fix informalities for you. And paper up the new matter issue as best you can, because if you lose that issue at the board, you're probably losing it at the federal circuit because of the substantial evidence standard.
And just to follow up on what Kevin said, with the proofreading, I have seen, proposed substitute claims that have had issues with them that have been part of the reason, the board has rejected them under 112. So especially when you have really long claims, which is in some of these cases, you need to have a couple people in there reading through the claims and going back and forth with the patent to make sure that you're not creating any issues. Another big thing that I've seen is, now that the board is giving preliminary guidance, the patent owners need to read that guidance really carefully. I've seen instances where the board has raised an issue in the preliminary guidance and the patent owner just didn't address it in their revised motion to amend. In one case, the board had a footnote that there was a 112 issue in certain one of the dependent claims. And it would have been, an easy fix, but they filed the revised motion to amend and didn't address it. So patent owners really need to carefully review that guidance that you're getting, so that you can be in the best position.
Yeah, so it sounds like, we talked about a lot of maybe deterrents or reasons why you wouldn't want to file a motion to amend. Like, there are so many other issues that can come up with 112 or 101 and the intervening rights issue. I guess, do any of you think that there are maybe specific circumstances in which you think there would be a benefit to filing a motion to amend?
I mean, go ahead, Kevin. Sorry.
Oh, no, you first.
I was just going to say, you already have a challenge pending against your patent. And so, if you don't feel strongly about the merits of your original claims, maybe it's one of the odd circumstances where the patent isn't actually involved in litigation yet. So or you're not planning to assert it. Maybe it, like Kevin said, it just has licensing value. But it does give you the opportunity in this proceeding that's already taking place to try and fix potential issues with your claims. Maybe they have a 112 issue that you can fix in addition to some other amendments. So I think it's only, like Alyssa said, about 10% of instituted IPRs that actually have motions to amend, but I do think there are circumstances where it makes sense.
Yeah, it's and I have heard tell of patent owners using the motion to amend process not so much as a means to directly amend claims, but it's almost like the contingents amendments that you see in European style oppositions, where essentially your first set of claims in your contingent motion to amend is what you present for preliminary guidance. You learn about the board's concerns. Then you file revised claims if the board is still concerned, which they statistically probably will be. Then you get a final written decision. You learn a little bit more. Then you file a reissue or re-exam based on everything that you've learned. And so that way you've got a couple gates before you're getting into reissue or re-exam, where you can kind of take a couple bites at the apple to figure out what the broadest set of claims you can sneak through is. Now, that said, that is a very expensive process, and the business proposition, or sort of the business case for doing that, is challenging is challenging, right? And it's certainly challenging to present to clients. I can really only see that being used for a high value patent that doesn't have any continuations or other family members pending, and would have enough patent term left in it to justify, the hit to the damages case I'm going to get hit with by intervening rights. And I'd also have to be comfortable that the technology I'm working in is not going to evolve so quickly that by the time I get the amended claims out via, either motion to amend practice or reissue or re-exam practice, that the claims actually still have commercial value. All of these sort of business constraints are really drive me more than anything, and I think drive the way I litigate these issues or think about litigating these issues. And I would encourage all of you, take sort of that business first approach. Really think about what your possible motion to amend will do in the scope of your overall proceeding and your overall business case.
Okay, thanks everyone. I think that was pretty helpful. So I guess we can turn to our next slide, where we are talking about notice regarding options for amendments by the patent owner through reissue or re-examination during pending AIA trials. I think.
Yeah, maybe I can speak to this one a little bit. So this was a notice that was put out shortly after the pilot program notice, and largely because I think certain people in the stakeholder community wanted more clarity from the office about how the office would deal with sort of co-pending requests for re-exam or reissue applications that were at the same time or near, while an IPR proceeding was pending, and particularly how to deal with amendments. Because I think, as Kevin alluded to, a lot of times amendments are more fruitful in re-exam or reissue than they are in IPR. And so this particular notice talks a lot about, for example, when the PTAB will stay a pending IPR proceeding, and how you can go about going to the CRU and getting claim amendments, even, potentially, for example, after your IPR is concluded.
Yeah, and I think this program, which, as somebody who represents patent owners, I absolutely love, is often a much better, much faster, and much more effective way to obtain amended claims than going through the motion to amend process. One especially cool feature is you can actually create IPR immune claims this way through re-examination. Because if you file a re-exam request, get some new claims, the 1-year bar for the petitioner filing an IPR after service of the complaint does not reset when you've got new claims. So if you get some new claims out of a re-exam, you potentially have claims that are immune to IPR against a petitioner whom you've served a complaint of infringement upon. Reissue, you don't have that benefit, right? Reissue produces a new patent, so it essentially resets the 1-year bar. But a cool feature about reissues is you can actually abandon them with no harm done, which is not something you can do for re-exams. You file one of those, they're going all the way. So one option available to patent owners is, get an adverse final written decision, but then file a reissue concurrently with your notice of appeal to the Federal Circuit. And at that point, if things go well for you in the Federal Circuit appeal and you get your claims back, you can simply abandon the reissue application and your claims come out same as they always were. So it's a way to kind of keep an additional chance to get some claims out in your back pocket. ultimately, the choice between re-exam or reissue depends on your litigation landscape around you and how concerned you are about anybody against whom you've previously asserted this patent filing another IPR. But those are very viable options. Both of them offer very limited opportunities for the patent challengers to participate. Re-exam, they're limited to notice of concurrent proceedings. Reissue, you've got reissue protests, and that's about it. So, and they're cheaper and they're usually faster too, especially because you've got a lot more control of the speed of those as the patent owner.
Kevin, I think there's sort of been the consensus that not that many patent owners are doing this. Do you have a sense of why? Is it basically the same reasons as just why we don't see that many motions to amend?
Yeah, I think so. I think to a very real degree, the business case just isn't necessarily there for pursuing amended claims for patent owners. Again, always got to think about intervening rights. Do you have enough patent term left to make this worthwhile? Or is the technical field you're in, is it possible that the patent challenger or the accused infringer will have designed around everything and or no longer even be in this field by the time you get amended claims out, whether that's by re-exam, reissue, or motion to amend practice. So, I think my view is that intervening rights are probably the #1 driver of why folks don't take advantage of this. It's the rare case where there's enough patent term left and enough of a royalty base or damages base available post intervening rights to make this worthwhile.
Thanks. So with that, I think we can turn to the next slide, which, so I guess we'll ask the panelists what the best practice tips are for petitioners.
So I can start here. I think we've been talking a lot about, these condensed timelines. So that's why the first tip here is on here. Determine quickly whether you need a new search to be conducted. Sometimes depending on how complex the amendments are that were added, you may have to find, all new art to address these claims, and that can take a few weeks in and of itself. So it's really important not to wait to review, what these amendments are. As soon as you get them, you need to be reading them, comparing them to the prior art you have, and determining what things you need to get searched. The second bullet point we have up here is to carefully consider any potential deficiencies to the statutory requirements. There are many of these motions to amend that are denied based on the patent owner either trying to enlarge the scope or having new matter in the claims. So it's important to really look at those and see if you have any good arguments that you can make. And then we've talked about this before too, you have additional chances to go after the patent under 101 and 112 that you didn't have in your original IPR. So those could be issues that were raised by the amendments or issues that were already in the claims that you now, have another means to challenge. And then motions to amend, say kind of in the last bullet point here, you don't have as many pages as you do in your original petition. So you definitely need to prioritize and kind of once you've gone through to determine what the statutory issues are and what the potential grounds may be, decide what your best options are and make sure you can, fully argue those.
So I think you talked about whether a new search would need to be conducted. In anyone's experience, do you think it's better to do a new search and bring in a new reference to the combination, or maybe that is more fact specific?
So in my experience, when I've been dealing with it, I usually, do look at the claims really closely and get a new search wherever I think maybe I'm the weakest. And then once I get the art, I can decide if I actually need those references or not, and how they fit best into my opposition. But because of the time constraints, it's kind of better to be safe than sorry and order a search to begin with, that's targeted to what you might need.
But yeah, that makes sense.
One other tip I wanted to mention, I don't think we've talked a lot about contingent versus non-contingent motions to amend, but another thing that makes this all feel a little bit onerous too is you can have a circumstance where you have a contingent motion to amend. So the patent owner is still defending the original claims and is saying to the board, essentially, if you find our original claims unpatentable, then consider these proposed substitute claims. And so not only do you have to do the opposition to the motion to amend, but you're doing the petitioner reply at the same time. And so just being ready to ramp up to handle both of those things, because you will know the motion to amend is coming because the patent owner has to confer with the board either by email or in a conference call before the motion to amend is filed. So being prepared to ramp up to get that search going, as Alyssa was talking about, to take whatever depositions you need, and at the same time, think through all these various issues is really important.
And the other thing is, one thing I think about is, can I make a very tight ground in terms of page count that is going to require an asymmetrically large response from the patent owner? And a lot of times that tends to come up in 112 issues. For instance, if you see an open-ended range, a lot of those aren't enabled. And there's a case, Maxwell versus Hitachi Federal Circuit case. You can often make an enablement ground against an open-ended range in mere sentences, and force the patent owner to do a lot of work to either defend that range as enablement or file a revised motion to amend to close that range and then find written description support for that range. Same for antecedent basis issues, same for lack of algorithm and means plus function claims. You've got a lot of low-hanging fruit on the 112 vine. Make sure you pluck it, especially where it's going to force the patent owner to spend a lot of their limited page count to respond.
Yeah, and that's a good point. On the petition side, 112.6 can be sort of the bane of a petitioner's existence, trying to deal with what corresponding structure may or may not be. And so, you can't argue as the petition that a claim is indefinite. But here, if the patent owner in their amendment, has 112.6 limitations, you can argue indefiniteness based on lack of corresponding structure.
Thanks, guys. So I think we have a little less than 5 minutes left, and I did want to, we could turn to the next slide, open the panel up to any questions we have from the audience. Again, you can feel free to just type the message in the chat if anyone has anything. I can. So it seems like we might have kind of a quiet audience today. So maybe if anyone wants to think about something, do any of the panelists have any, closing thoughts on motions to amend they want to share?
We do have a question on the chat.
Oh, I see one just popped up. So the question is, when you said equitable estoppel, can you explain that further?
Yeah, sure. I can jump with that. I think I meant equitable intervening rights. So when you think about when a claim is amended, right before the claim is amended, the petitioner, the patent challenger is going about, they're manufacturing articles that meet claim limitations of the original claims, and maybe they also are accused of infringing the amended claims as well. But if you've got some essentially some substantial prep, but those claims, you know, didn't previously exist, right? They were just not there, and the original claim would have been held invalid. So at some point, the regime to which the accused infringer, you know, did not feature a patent that could be enforced against them, or a patent claim that could be enforced against them, and now it does. So with equitable intervening rights, there's essentially a notion that it's only fair that once the accused infringer has, or I'm sorry, once the patent owner has obtained these new rights that they could conceivably enforce against the infringer, you know, if the accused infringer has made some substantial preparation before this patent issued, this new claim issued that would be valid despite the invalidity, or rather unpatentability, of the old claim, there's some sort of notion of fair play there, where you know, the accused infringer will be allowed to sell some stuff or make and use some stuff that might be covered by the new claim, because there's been this sudden change in the landscape of patent claims with which the petitioner is faced, but only for a certain limited time, after which, you know, the accused infringer has had notice of the patent. It knows that there are valid patent rights out there that could cover what it is doing. And so that's why equitable intervening rights are time limited. It gives a little bit of leeway, a little bit of equity to the accused infringer, but after enough time has passed, and the accused infringer is still doing stuff that infringes the new claims, at that point, you know, equity says, all right, you're infringing now. We need to give the patent owner, you know, their due.
And we have another question that this is probably all we have time for. This is for Kevin. When you said that new claims out of a reexamination are immune to IPRs due to the 1-year time bar from the date of the district court litigation filing, is it true that a post-grant review can still be filed within 9 months of the issuance of new claims?
So I believe that when we're talking about post-grant review, we're talking about the patent issuing date. And so a re-exam produces, it doesn't produce a newly issued patent. What it produces is new claims within an existing patent. So I believe it also makes those claims PGR immune. I don't have that answer offhand. I haven't seen anyone try that. But I believe they are, as if once the PGR window closes for a patent, it closes for good, even if new claims are added by re-examination. So I don't have, you know, I'm not 100% sure about this, but I don't believe that those claims would be subject to PGR. Now, reissue, you know, again, different question. Reissue produces a new patent, and so you've got clocks resetting there.
Yeah, but still, you'd have to look at the priority date.
Yes, that too.
Like that, and I think you can correct me if I'm wrong about this, Kevin. I don't think the issue of whether the 315B bar resets for new re-exam claims, I don't think that's been tested yet, but I think that's how most people have interpreted the statute.
Yeah, it's how panels it's certainly how panels of the board have interpreted the statute. I think but I don't think we have definitive Federal Circuit case law on that, and I'm not sure we necessarily would get it, just because I think it's insulated from judicial review under the click-to-call case.
Right.
All right. Well, I think that's all we have time for today, but thanks everyone